Alrighty. Welcome everyone. This is welcome to the Henderson Alliance webinar, Legal Challenges for SMEs in a Pandemic. I'm your host, Colleen Yates, Deputy Chair of the Henderson Alliance and also CEO of Regional Development Australia, Perth. Now this is our very first webinar and it is being recorded. We will have the presentation and afterwards there will be opportunities for you to ask questions. Questions can be typed, or if you would like to voice your question, there's a little thing there for you to raise your hand and I will turn on your sound. At the end of the event, we will run a short questionnaire, so please can you answer that before leaving. For those of you that may not be members of the Henderson Alliance is a dynamic and progressive alliance of small to medium enterprises, taking positive action to work collaboratively and build capacity to create better business environments with new opportunities generated in defense-related industries and other specialized sectors of advanced manufacturing. If you'd like to know more, you can visit our website at hendersonalliance.org.au. So now I'd like to introduce our guest speaker and also a Henderson Alliance member, Mark McLennan. Mark is a principal lawyer at Bennett & Co. and he heads up their defense and aerospace practice group. Mark has had a career as a lawyer for nearly 30 years in Australia and New Zealand. Mark has advised and appeared for numerous organizations, including large and small companies, public companies, and government bodies in court proceedings, mediations, and arbitrations. Mark is listed as a recommended lawyer by Doyle's Guide and the leading commercial litigation and dispute resolution lawyers for Western Australia for 2015, 2018, and 2019. A very warm welcome to you, Mark, and we look forward to hearing your presentation. So now over to you.
Well, thanks very much, Colleen, and welcome everybody. Thank you for registering and thank you for tuning into this Henderson Alliance and Bennett & Co webinar. As Colleen said, Bennett & Co is a member of the Henderson Alliance and I'm proud to sit on the board of the Henderson Alliance. I must say on my blurb, I don't know, I must take off the reference to a career of nearly 30 years because every time somebody reads that out when they're introducing me, it just makes me feel depressed and reminds me of how old I am, so I need to do something about that. So this webinar is about the legal impact of the COVID virus or the economic consequences of the COVID virus on SMEs in Western Australia. And I'm doing this webinar from the perspective of companies that are in the WA defence space. But the points that I'm going to talk about are of general relevance to construction and engineering contracts and to commercial contracts generally. So I hope that even if you're not in the defence space, you'll get something out of this. So this webinar was planned at a time when COVID was sort of on its way towards wreaking havoc right across Australia for SMEs. And thankfully, we're now starting to emerge from the physical lockdown that's been such a handbrake on business. But even though we're emerging from the lockdown, it's quite clear that the economic and the legal consequences of COVID are going to be with us for months and maybe years ahead. So with that short introduction, and I should say that there'll be time for some questions at the end, but as Colleen said, if you want to send any questions through in the meantime, please don't hesitate to do so. And if I can answer them, I will. If I can't, I'll take them under advisement, and I'm more than happy to talk to anybody offline who might want to give me a call. So just in terms of what I'm going to cover in the webinar, essentially two topics, and to express the topics at a general level, I'm firstly going to talk about the responses of governments, federal and state, from a legal perspective to COVID. And then secondly, I'm going to look at a series of clauses that I've taken from a review of a number of defence-specific contracts and just talk about how COVID is likely to impact on typical contracts between primes or principals on the one hand and SME contractors on the other. As I'm going through, I'm going to try and talk about how you can deal with some of the issues that arise within your own businesses. I'm going to try and talk generally about how you can future-proof your business against the adverse consequences of COVID. So going firstly to it's a tip for beginners to make sure you turn your phone off before you start your webinar. So going firstly to the statutory instruments and responses of government to COVID. Look, just by way of background, we're all very well aware of what COVID has done in a practical sense. We have social distancing restrictions across the country, but in particular in workplaces. Businesses have experienced travel bans and border closures. So we're only just at a stage where we're allowed to travel within Western Australia. We can't yet travel out of Western Australia, and of course we certainly can't leave the country. So with those sort of restrictions, how are businesses responding? Well, some businesses have been virtually unaffected, but the majority of businesses have experienced some kind of negative impacts. There have been temporary and permanent closures, site shutdowns, businesses have stood down or unfortunately had to dismiss or make employees redundant. Business activities have been scaled back. We've had this phenomenon of WFH, working from home, which I presume is going to make it into the next edition of the Oxford English Dictionary. Complete bans effectively on staff travel. Businesses, where they've been able to do so, have moved or put focus on the online side of their business. Businesses' supply chains have been interrupted, particularly if they're dependent on foreign overseas suppliers. So people have had to identify new suppliers, identify new markets. And of course, if we think about mining companies, they've had to put in place intensive COVID testing regimes to try and protect their remote mine sites and keep them operating. So a whole range of different responses from business, all of them expensive and all of them debilitating. Fortunately, our government moved pretty quickly, the federal government moved pretty quickly to try and insulate business to some extent from those adverse economic consequences. And I'm going to talk about some of those measures. I'm going to talk about JobKeeper, which I think we all know about. I'm going to talk about the commercial leasing code, which to my mind is as important as JobKeeper, but tends to fly under the radar a little bit. And finally, I'm going to talk briefly about some mitigatory measures in relation to corporate insolvency and personal bankruptcy that have been put in place just for the duration of the COVID emergency. So I'm just going to start by talking about JobKeeper. Now, I expect that everybody listening to this webinar is generally familiar with JobKeeper. Maybe your businesses have at least registered for JobKeeper, and maybe some of your businesses are actually in receipt of the JobKeeper payments. But you can still register for JobKeeper if your business's performance has reached the criteria, if I can put it in that way. JobKeeper started in March and it's due to expire in September of this year. That's a pretty hot topic, of course, in Canberra at the moment, because a lot of people are saying that if you're suddenly in JobKeeper, the shock to the economy is just going to be, it's going to be worse than the cost of keeping JobKeeper going in some form. So I think what we're going to see, rather than a complete termination, is just a reduction in scope or a kind of a tapering of the JobKeeper scheme. But basically, to qualify for JobKeeper, businesses have to have sustained a 30% drop in revenue for a month starting in March as compared with the same month in the previous financial year, or it can be on a quarterly basis. And if that can be demonstrated, then businesses are entitled to $1,500 per fortnight per employee. The $1,500 actually has to be paid to the employee, and it effectively gets rebated by the ATO, who are charged with administering the scheme and making payments. Employees who are earning less than $1,500 obviously get a bit of a windfall because their income is increased to $1,500. Where an employee's been earning more than $1,500 a fortnight, then it's for the employer to top up the difference. But due to some changes to the Fair Work Act, temporary changes to the Fair Work Act, employers are able to reduce the amount of work that they require from the employee to bring it back down to the equivalent of $1,500 per fortnight. Due to some other temporary amendments to the Fair Work Act, there's the ability for employers acting reasonably to direct employees to take annual leave, and the $1,500 per fortnight is payable to employees who have been stood down. So that's just a little summary of JobKeeper. It's been a hellishly expensive exercise, obviously, for the country, but not as expensive as the government predicted that it was going to be, as we know. And it will be interesting to see at the end of September whether it's carried on, and if so, in what form that it's carried over to the new year. So that's JobKeeper, and the next measure that I wanted to talk about, and it kind of runs in parallel with JobKeeper, and it's analogous to it in some ways, but it's the Commercial Leasing Code of Conduct. And I actually don't know what level of uptake there has been, because obviously we're talking about private arrangements between a landlord and a commercial tenant. But basically the Commercial Leasing Code was promulgated by the federal government, and the code's been enacted in each state and territory by those states and territories. And relevantly to Western Australia, the Commercial Leasing Code of Conduct is enshrined in the Commercial Tenancies COVID-19 Response Act of 2020. Now, the Commercial Leasing Code runs for the duration of what is described as the emergency period, and the emergency period runs from March through to the end of December. And basically the Commercial Leasing Code applies to businesses with an annual turnover of less than $50 million a year who are eligible for the JobKeeper program. So we have experienced the 30% fall in revenue, and you're eligible for JobKeeper, then it will automatically apply to your business. And what the Commercial Leasing Code of Conduct tries to do is to kind of balance out the economic consequences of COVID as between landlord and tenant. And the way it does that is to say that landlords have to reduce their rent, and I emphasise, not outgoings, proportionately to the reduction of the tenant's business turnover. So if you qualified for COVID, it's qualified for the leasing code, it's because you've sustained a reduction of at least 30%, so let's work on 30%. And of that 30% reduction in rent, at least half of that has to be by way of waiver, and waiver means that the landlord forever forgoes its entitlement to recover that 50% portion of the rent reduction, and the balance of it has to be by way of rent deferral. So as you would think, deferral means that the rent is ultimately recoverable, but it's recoverable over an extended period. That period is either a period equal to the balance of the term of the lease, or 24 months, whichever is longer. So, and it gets amortized over that period, which, as I say, is at least 24 months. So within the emergency period through until December, again, question mark as to whether that'll be extended, landlords can't terminate a commercial lease for non-payment of rent, they can terminate for other breaches, but not for non-payment of rent. They can't charge interest, even if interest is provided for under the lease. They can't impose penalties on tenants, for instance, retail tenants in shopping centres who don't open the number of hours they're required to be open. To kind of balance things up, landlords are entitled to reduce the level of service that they provide, so maintenance services, security services and that sort of thing. Landlords who achieve any kind of statutory, any savings, for instance, in land tax or whatever it is, are obliged to pass on an appropriate portion of that saving to their tenants. And finally, landlords aren't allowed to call upon any securities that they might have for payment of rent. So, for instance, if a director has given a personal guarantee, that would be an example of a security, but during the emergency period, the landlord can't call upon. So again, that's just a brief outline of the commercial leasing code. And if you want some more detail, I mean, there's lots of stuff on the internet about it, but you can look on our Bennett & Co website. There's lots of stuff there, or feel free to give me a call. And the third and final topic that I wanted to talk briefly about in relation to government measures for COVID is in relation to insolvency and personal insolvency and corporate insolvency. And I guess most of you in business will be aware that when a business is unable to pay, company is unable to pay its creditors, the usual mechanism for collecting the debt is to issue what we call a statutory demand under the Corporations Act. And a statutory demand is a piece of paper that demands payment of the amount within 21 days. And if payment's not made, then the company, the debtor, is deemed to be insolvent within the meaning of the Corporations Act. And that can have all sorts of horrible consequences. For one thing, it means that the creditor who issued the notice, or any other creditor who wants to piggyback on that, can apply to wind the company up. But it also means that you're probably going to be in breach of the covenants under your bank documents and financing agreements and that sort of thing. So it's pretty terrible. And there's a sort of an analogue process for personal bankruptcy. So an individual can be served with a bankruptcy notice. So what the government has done is that they've made some temporary changes to the Corporations Act to provide that, whereas previously you could issue a statutory demand for as little as $2,000, and in the case of bankruptcy for $5,000, in both cases that's been extended to $20,000. So you can't issue a statutory demand or a bankruptcy notice for less than $20,000. So that provides a measure of protection to an SME. As well as that, the compliance period has been extended in both cases from 21 days to 6 months. So the presumption of insolvency won't kick in for at least 6 months if the debt isn't paid. So again, a valuable measure of protection. In addition to that, the government has made some further amendments to the Corporations Act in relation to the 2017 safe harbour provisions for directors. And essentially what happens is for the duration of the emergency period, directors are shielded to some extent from the consequences of insolvent trading. Now, there are some restrictions on that. It only applies to debts incurred in the ordinary course of business, and it only applies where there's a complete absence of dishonesty or fraud. But that is a very substantial measure, because it's very hard for a business and for directors in this environment to know how close they are to the line of trading while insolvent. And so this measure gives them a level of security to carry on and to try and keep the business afloat, and I suppose it protects them from the consequences of responsible risk-taking, if I can put it that way. So that is the additional protection for companies from insolvency and for directors for insolvent trading. And yes, Look, what we've done on this slide, and I'm not going to go through this, but what we've done is we've compiled a list of all of the financial benefits that are available to SMEs. Some of them are state government, some of them are federal government. Some of these benefits get paid without you even having to apply for them. There's a whole range of them to do with increased payroll tax thresholds and instant asset write-offs and things of that nature. And as I say, I'm not going to go through them, but what I invite you to do is look at you'll be able to access the slide, so have a look at the slide and just make sure that your business is claiming all of the benefits that it could possibly be entitled to. If you're not sure, obviously speak to your accountant. If your accountant's not across all of these things, don't hesitate to give me a call. I'm happy to put you in touch with somebody who's happy to chat over the phone about these various benefits that are available to SMEs. But again, some of them are pretty substantial, so it's well worth spending a few minutes just to make sure that you're on top of these. So that's all I wanted to say about the things that governments have done in relation to COVID. What I wanted to do now is I wanted to move on to what COVID has done to contractual relationships and contracts between commercial parties. Because there's probably not a single contract that is not at least potentially impacted by the economic consequences of COVID in some way or another. I mean, not all contracts are of equal importance, obviously, and so you really need to focus on the mission critical contracts in your filing cabinet. But problems are going to arise either because you can't perform your obligations under the contract, or you can't perform them in the required time frame, because your principal can't perform. For instance, they can't afford to pay you, or they can't import the equipment that they need to supply to you to do your job, or your supply chain might be struggling and be unable to perform their obligations to you. So there are a bunch of ways that COVID potentially does violence to contractual relationships and commercial contracts. And the whole range of contracts can be impacted, and obviously we're concerned about critical contracts with primes and head contractors and your critical suppliers, but it also extends to your employment contracts and things like termination payments and redundancy payments, and making people take annual leave, whether people can use personal leave if they have to self-isolate because they've been in contact with somebody from COVID. There's some suggestion that they can't. And leases of premises and property, leases of equipment and so on. So all of these contracts are potentially affected directly or indirectly by COVID. And when something like COVID comes along, there are kind of two general legal concepts that come into play, and I'm sure you've heard of them both. The first one is called force majeure, and most contracts contain what we call force majeure clauses. And the second concept is called frustration of contract, and both of these concepts come to us from the English common law. They're many hundreds of years old. So I'm going to deal firstly with frustration, and I'm going to deal with that really quickly because it probably won't apply in a lot of cases. But basically the doctrine of frustration says that if something happens like COVID, that means that the party or a party's ability to perform the contract in the way that it was intended to be performed is now virtually impossible, or performance of the contract in light of the calamity that COVID would be a substantially different thing to what the parties contemplated when they entered into the contract. What the doctrine of frustration says is that the contract comes to an end, bang, just comes to an end. And the losses as a result of that lie where they fall. And you can see that that has the potential to be completely unjust and really arbitrary in the way in which the losses that flow from the termination of the contract are adjusted between the parties. So you could end up with effectively one party bearing the whole of the loss caused by the frustrating event in this context, the COVID. The usual example of frustration relates to the complete destruction of the subject matter of the contract. But in the context of COVID, it could also arise in a situation where time for performance was of the essence in the contract, and COVID prevents that occurring. And if the contract can't be performed by the specified date, then it has no value to the other party, essentially. And that is likely to be an event of frustration. So having said all that, I do need to say that frustration won't apply if the contract deals with the prospect of an event like calamity in its own terms. But as I said, frustration it's an old legal doctrine. It's many hundreds of years old, and at the time it came into being, we didn't have word processors and computers, and contracts were normally 4 or 5 pages long at the most. But with the glorious proliferation of lawyers and computing power, we now very rarely have a commercial contract that's less than 40 or 50 pages, and quite often they're 100 or 200 pages by the time you take into account standard terms and conditions and schedules and all of those sorts of things. So, and so what modern contracts try and do, and modern lawyers try and do, is they try and think about all of the what ifs. What if this happens? And then they try and build those into the contracts. So, and those are what we call force majeure clauses, and most modern contracts have them. So what I've done, I should say, for the purpose of this webinar, is I've been through a whole bunch of common defence industry contracts here in Western Australia for the major projects, so for contracts like for the OPVs, things of that nature. And what I've tried to do is identify the relevant force majeure clauses, and so I'm going to go through in the next part of the presentation and look at a number of those clauses. So a force majeure clause is a clause that firstly contemplates a particular event. Now, there aren't many contracts that contemplated COVID, but they do contemplate circumstances that are expressed at a level of generality, such that if the circumstances prevent one or other parties from performing their obligations, and the circumstances weren't reasonably foreseeable when the contract was entered into, then the force majeure clauses will generally deal with what's happened, and COVID will generally be a force majeure event that invokes these protective clauses. So a force majeure is a calamity or a force or circumstances beyond the party's control, and if the contract deals with them, then you need to go to the contract and you need to say, you need to see how the contract adjusts the parties' rights, and how it controls the right of termination of the contract, and liquidated damages, and entitlements to extensions of milestones and things of that nature. So what are the issues that are likely to arise from a contractual point of view as a result of COVID? Well, you can probably think of other ones, but the ones that come to my mind are these. Firstly, penalties for delay and non-performance, postponement of delivery and milestone dates and the consequences of that. I suppose most dramatically, the termination or suspension of contracts or parts of contracts, suspension of payments, liquidated damages, and consequential losses. And some other issues that are likely to arise, and I've touched on some of these briefly, but liability to employees. So obviously, if a company is experiencing financial hardship and has to lay people off, then there are legal issues that arise there. I've mentioned the triggering of default events under loan agreements and personal guarantees, and these can feed directly into a problem in, for instance, a contract with a prime, because if one of these things happen, that could be an insolvency event, which is a defined term under most of these contracts. And if you suffer an insolvency event, then that can lead to certain consequences under the contract. And an insolvency event can be something like entering into an arrangement with your creditors to defer or reduce the amount of debt, for instance. That can be an insolvency event. Or for a statutory demand, not to be complied with, and of course you've now got 6 months, but for it not to be complied with, leading to a presumption of insolvency, that can be an insolvency event. And of course, if you know, your bank appoints a receiver or something like that, then that would obviously be an insolvency event. And I think towards the second half of this year, we are unfortunately going to see, notwithstanding all the measures that have been put in place, I think it's likely that we are going to see a whole lot of these unfortunate things happening, with companies going into liquidation, external controllers being appointed and that sort of thing. Other issues that are likely to arise as a result of COVID are contractual disclosure requirements. And I haven't got a slide for this, but in one of the standard form OPV contracts, there's a condition about disclosure that I thought I'd read to you. It says the subcontractor shall promptly and fully disclose to the prime, in square brackets, in writing, any event or occurrence, actual or threatened, during the performance of the contract which may materially affect the subcontractor's ability to perform any of its obligations under the contract or the prime's obligations under the head contract. So if an SME finds that it's unable to perform its obligations under its contract, the provisions of that clause that I just read out would undoubtedly require it to disclose that fact to its principal or head contractor. And finally, although this webinar is really directed at SMEs, listed companies, of course, have their continuous disclosure requirements under the Corporations Act. Now, there's been some amelioration of those requirements because of COVID, but essentially listed companies have to disclose events that might have a material impact on their share price, and there's no doubt that COVID in certain cases could be one of those events. So what are some examples of problematic clauses in contracts? Well, again, you can probably think of other examples, but these are the ones that come into my mind. Firstly, unilateral termination without cause, termination for cause or for breach, suspension of work, scope reduction, delayed and staggered time for payments. Of course, there's been some, in the defence sector, there's been some policy announcements around that. Suspension of payments, contractor initiated postponements of contracts, and liquidated damages. So if we turn firstly to termination without cause, so I've just got a clause up here. It's out of the, again, out of the standard terms and conditions for the OPV project. Generally speaking, the law doesn't like contracts where one party can unilaterally bring the contract to an end without any fault on the part of the other party, because it's not helpful to have that sort of arrangement in place if you're talking about a commercial agreement. And if you think about a high value defence contract, for instance, as a subcontractor, you probably spend an awful lot of money actually getting the work in the first place. Then once you've got the work, you probably spend a whole other bunch of money gearing up to perform the contract, hiring staff, hiring equipment, maybe leasing new premises, maybe if you're talking about the submarines, maybe sending staff to France and setting up an office in France. So there's a huge investment. And quite often it'll be the case that the return on that investment doesn't sort of come until towards the back end of the contract. And you can see it's a pretty horrible concept that a principal can just at any time terminate the contract, but that is what can happen. And so if we look at this clause, it says that in addition to its other rights, principal can terminate the contract at any time by notice to the contractor. In this particular contract, it says the notice must state the date the termination is effective, and this must be not less than 5 business days from the date the notice is deemed to have been received. And then this is the bit that to me as a lawyer is quite scary. It says that none of the other provisions of this contract limit the principal's ability to terminate the contract or any purchase order quote, for convenience. So principal can terminate the contract for convenience. And if that happens, what sort of compensation is the subcontractor entitled to? Well, not very much is the answer. So firstly, the contractor is entitled to be paid for the work that's been done as at the date of termination. So even if there's been no progress claim issued or invoice issued, but you've done the work, you're entitled to get paid for it once you render an invoice and subject to the other conditions for payment. And then you're entitled to any reasonable direct costs incurred by the contractor in complying with the notice of termination. So not direct costs associated with entering into the contract, but direct costs associated in complying with the notice of termination. That would obviously include things like repatriating staff who were overseas, shutting down a work site, shutting down equipment, delivering product back to the prime or the head contractor, returning Commonwealth supplied equipment and things of that nature. But what about other stuff like termination payments to staff who have to be laid off because of the termination, or paying out equipment leases? What about reimbursement for the upfront investment in plant and equipment and machinery? Now, to my mind, this will be tested, I'm sure, in the fairly near future. To my mind, these things probably don't come within the heading of direct costs associated with complying with the notice of termination. And one thing that certainly doesn't come within that definition is profit. And you can see here, this provision, contractor will not be entitled to profit anticipated on any part of this contract or any purchase order that is subject to termination. So no entitlement to profit, and the example that I gave previously of a contract where all the profit is at the back end, pretty devastating stuff for an SME if that actually happens. Now, less controversially and more, I guess we're more familiar with this, is that a contract can be terminated for cause. So you'll be familiar with the process. What happens is that if there's a breach of the contract by the subcontractor, the principal or the prime can issue a default notice. If the principal, in its discretion, thinks that the breach is capable of being remedied, it can specify a period of time in the notice for remedying the breach. The contractor doesn't remedy the breach, then the contract can be terminated. If, on the other hand, the principal forms a view that the breach cannot be fixed, can't be rectified, then they can just issue a default notice, but not provide an opportunity to rectify. They can just terminate directly as a result of the breach. Now, I should say here that, actually, I'm just going to go back to the termination for convenience slide. I should say here that, so I'm picking clauses in isolation, and these are clauses that principals can rely upon, but at the end of the day, you have to look at the contract as a whole. And it's not quite as bad as it seems, because in a circumstance like COVID, a contractor can apply for a postponement of an obligation, for instance, in some circumstances, which would avoid this consequence. And the other thing I should say about this is that the law in commercial contracts has things called implied terms that basically prevent parties from acting maliciously or arbitrarily. So in this termination for convenience example, if a principal terminated the contract for reasons that didn't have any legitimate connection with the economic interests of the principal, were arbitrary, or for some purpose completely outside the contract, then the courts probably wouldn't uphold a termination of that sort of nature. So termination for cause, I've mentioned insolvency events. So if a receiver's appointed, or failure to rectify a breach that's specified in a default notice. Generally speaking, if there's a termination for cause, then you're not entitled to any compensation, and indeed it's probably going to be the other way around. You're potentially liable for liquidated damages or special damages. So those are the two most drastic consequences, I suppose, potentially of COVID, termination of your contract. But there are a range of less serious measures that a principal can take because of COVID-related events. So suspension of work, and the suspension can be justified by an act or omission of the contractor, for instance, defective workmanship or a clear inability to perform the contract. But it can also be driven by the principal. So, you know, to give an example, the principal might have experienced a delay in receiving some equipment from overseas that needs to be supplied to you as part of the performance of your contract. It may be that the government, the Commonwealth, has slowed down a particular contract, if we're talking about one of the big defence contractors. So the principal can suspend work breached by the contractor because of problems that it's got, or, and if we look at this one down here, for any other reason. So again, pretty broad powers to terminate or suspend work under a contract. Now, I should say that most of the contracts that I've looked at are loosely based on the Australian Standard for Defence Contracting suite of documents, or as DEFCON. And so what tends to happen is, so between the Commonwealth and the Prime contract, with all of these types of provisions in it, is sort of mirrored in that contract. And then when you go down the chain, what you find is that the protections and the clauses kind of get watered down in the back-to-back contracts between Prime and subcontractor and further down the chain. So most of these powers to terminate for convenience are all found in those as DEFCON suites of documents. And I guess you can understand the reasons. These are very high value contracts. They're subject to the political winds of change, so there does need to be that sort of flexibility. So suspension of work, and in a similar vein, scope reduction. So again, if there's a COVID-related event, or for any other reason, in fact, the principal has the sole discretion in most contracts, and this is just an example of a term, to remove services or part of services. This is from a service contract at any time by notice. Again, limited rights of compensation on the part of the contractor. Obviously, you're entitled to be paid for the work or services that you have provided, but in terms of this particular clause, you're not entitled to any further compensation for the removed services. A lot of these contracts have provisions that enable the principal to slow down or suspend payments. Now, I've got a bit of an asterisk there because I think people in the defence space will be aware that there are now policy directives that I don't know if they require, but they encourage primes to make payment. I think it's within 7 days after the prime receives payment from the Commonwealth, but generally speaking, that period's been sort of in the region of 40 days. And under some provisions in these contracts, the principal or the prime can completely suspend payments. And again, that can potentially have a fairly severe impact on an SME or a small company. Contractor can, and this is another clause from a typical contract, a principal can postpone, sorry, just going back to, so a contractor can seek a postponement. So if a contractor, potentially because of a COVID circumstance, becomes aware that they're not going to be able to perform their contract, they can seek a postponement, and most contracts contain a clause like this. Contractor shall be entitled to postponement to the extent that a postponement event is beyond the reasonable control of the contractor and couldn't have been reasonably contemplated. And if that happens, contractor is entitled to an extension of time, a reasonable extension of time. Again, any losses that the contractor sustains because of the delay the contractor has to wear, and probably any losses that the principal sustains, the contractor has to wear those as well. there is a provision for the recovery of costs if there's a postponement by a principal, and that will happen, sort of case that I previously talked about, where, for instance, the prime might not be in a position to proceed immediately with a part of the contract and the principal wants to postpone the contract. If that happens, then in accordance with this clause anyway, which is a fairly typical clause, there is an entitlement on the part of the contractor to compensation. But you can see that there are fairly onerous record-keeping requirements. So the advice there is that if you're in that sort of situation, you need to get your accountants involved at an early stage and start putting together your compensation case and keeping all your records. Look, I just want to talk briefly about liquidated damages, because all contracts contain formulas for liquidated damages. It just means that the principal doesn't have to go to the trouble of exactly calculating their loss and damage, which in complex commercial cases can be a very difficult thing to do. And if it's not going to be liquidated damages, it's going to be special damages, where the exact measure of damage does have to be calculated, but there's a scope for those damages to be much higher than the liquidated damages. This is just an example of a liquidated damages clause. So if a milestone is not achieved by the applicable milestone date, liquidated damages will be calculated based on a percentage of the contract price per working day. So you probably all would have seen those sorts of clauses. So look, I've raced through those last few slides a little bit because I did want to get to the conclusion of the webinar, which is, and how do you deal with these sorts of issues when they arise? And I suppose what I say to people is, go to your filing cabinet and pull out your most important 2, 3, 5 or 10 contracts. Maybe some of them you haven't looked at since the day you signed them. And just with what I've said in mind, and just the type of clauses that I've been talking about in mind, have a good critical look through them and just see if you can identify any potential problems in those contracts, having regard to the effects of COVID on your business, interruptions to your supply chain, interruptions to your factories and your employees, and just see if you can identify any actual or prospective problems. If you're unsure, speak to your solicitor, speak to your accountant about whether there are any financial issues that arise for your business. And if there are any problems, then the advice, and it's common sense rather than legal advice, but the advice is get on the front foot. Don't bury your head in the sand. So go to your contract counterparty and talk about the problem. Because if you have to get into an arbitration situation or even mediation or, heaven help us, the Supreme Court, you just don't want to be there at this particular time in the economic cycle. So get on the front foot, be proactive. And I guess the final piece of advice that I wanted to say is, if you're moving into this space of a potential problem, record keeping becomes absolutely critical, whatever side of the fence you're on. Keep records up to date. Need be, get your accountant involved to do analyses and prepare special purpose accounts and things like that. It's so important to keep really good records. So look, I'm not sure whether we've got any questions, Colleen, but if we have, then I think we've got a couple of minutes to provide some answers if I can.
Okay, so I'm going to open up to all the attendees. As I said previously, there's 2 ways to ask a question. You could actually type a question in the Q&A, or you can raise your hand and I can turn the sound on and you can just ask the questions directly. So are there any questions from anyone? Okay. No? Oh, that must have been a very comprehensive bit of information that you've provided, Mark.
Good, please. All right. Oh, sorry, Colleen, were you going to say something to it? No. I was just going to say, well, look, thank you very much for joining us in this webinar, and on behalf of the Henderson Alliance and Bennett & Co, thanks very much. And if you're interested in becoming a member of the Henderson Alliance, well, obviously contact Colleen or one of the other board members. And if there's anything about today's presentation or anything that flows from today's presentation, look, please don't hesitate just to pick up the phone and give me a call. I'm happy to just chat through any sort of queries that you've got and help you out if I possibly can. So,
and I've just issued a bit of a poll. If you can all answer those, there's just a few questions there quickly before we end this webinar, that would be fantastic. And I'd like to say thank you so much, Mark, for coming on and talking about this very important subject. And thank you to all the attendees for our first Henderson Alliance webinar. So thank you. Please fill out the poll before you go. Thank you.
Can I talk? Thanks, Terry.